Statutes, codes, rules, and regulations. Statutes are not laws. With such overwhelming case law, there is no question about the fact of the claim made here. Statutes are not law. Plaintiff / the court now challenges prosecution and magistrate to prove the statutes applied to plaintiff / court. Plaintiff denies being a government employee. If the prosecution or state or magistrates wish to say differently, then prove that I have been a paid employee of the federal or state government. As well, Article 1, Section 8, Clause 14 says clearly the government makes the rules for the government, not the people. And I guess this is cited in Cruden versus Neal 2 NC 338, 1796, 2 SE. Apparently that's the code that you can go ahead and look up to verify any of the claims made here. Constitutionally, a statutory presumption cannot be sustained if there is no rational connection between the fact proved and the ultimate fact presumed. And so the case here is cited below as well for you to go ahead and verify and to fact check anything here, because I mean, you really shouldn't believe anything unless you verify it on your own. So take nothing that I say as facts or truth, and I'm not even claiming them to be any. This is just something to make you think. So here it says as well, statutes apply only to state-created creatures known as corporations, no matter whether creature or statute, and offices of state, local, or federal government. A statute will not be presumed to have extraterrestrial or extraterritorial effect outside the territorial jurisdiction of the legislature over persons residing outside the territorial jurisdiction of the legislator. A concurrent or joint resolution of the legislature is not law. Lacking due process of law in that they are void of ambiguity in their failure to specify the statute's applicability to natural persons, otherwise depriving the same of fair notice, as their construction by definition of terms aptly identifies the applicability of such statutes to artificial or fictional corporate entities or persons, creatures of statute, or those by contract employed as agents or representatives, departmental subdivisions, offices, officers, and property of the government, but not the natural persons or American citizen immune from such jurisdiction of legalism. All codes, rules, and regulations are for government authorities only, not human/creators in accordance with God's laws. All codes, rules, and regulations are unconstitutional and lacking due process of law. The common law is the real law, the supreme law of the land. The codes, rules, regulations, policies, and statutes are not the law. They are the law of the government for internal regulation, not the law of the man. In his separate but equal station and natural state, a sovereign foreign with respect to government generally. The general rule is that an unconstitutional statute, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the time of its enactment and not merely the date of the decision so branding it. The legislature, it may not violate constitutional prohibitions or guarantees or authorize others to do so as well. Every man is independent of all laws, except those prescribed by nature. He is not bound by any institutions formed by his fellow man without his consent. Insofar as a statute runs counter to the fundamental law of the land, the Constitution, it is superseded thereby. All laws which are repugnant to the Constitution are null and void. Where rights secured by the Constitutions are involved, there can be no rulemaking or legislation which would abrogate them. The claim and exercise of a constitutional right cannot be converted into a crime. There can be no sanction or penalty imposed upon one because of this exercise of constitutional rights. To disregard constitutional law and to violate the same creates a sure liability upon the one involved. State officers may be held personally liable for damages based upon their actions taken in their official capacities. If the U.S. Supreme Court acknowledged the authority of the common law grand jury, U.S. versus Williams, why would the state have authority to counter that opinion? The common law is superior to all statutory law, and we must only invoke it in the right way to have superior standing. We need to stop putting the common law and the grand juries underneath the inferior statutory laws. The people, singular and plural, have the ultimate authority. American Jurisprudence, Second 1964, Volume 16, Constitutional Law, Clause 177. Generally, statute leaves the question that it purports to settle just as it would be had the statute not been enacted. Since an unconstitutional law is void, the general principle follows that it imposes no duties, confers no rights, creates no office, bestows no power or authority on anyone, affords no protection, and justifies no acts performed under it. A contract which rests on an unconstitutional statute creates no obligation to be impaired by subsequent legislation. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. Indeed, insofar as a statute runs counter to the fundamental law of the land, it is superseded thereby. It is said that all persons are presumed to know the law, meaning that ignorance of the law excuses no one. If any person acts under unconstitutional statute, he does so at his own peril, and he must take the consequences.